I am Raj from LawSikho, and today we have our guest. He's a in-house counsel. He's a deputy general counsel at HT Media, which is a very famous company. All of you know for sure. And we have him today to discuss a very important topic, very topical, very relevant right now. And we are going to talk about how the government has banned the apps. 59 different apps, and in fact today's news is that America is also considering to following the same and going to ban Chinese apps in America. It's a discussion till now, but could happen very well. And there are of course legal issues around this. There are a bunch of issues. One is of course within Indian law. Then apart from that, India is part of certain international treaties, bilateral investment treaties especially, and then WTO. There are multiple, international law aspects to this as well. Let us take a look at, starting with Indian law and how Indian government and Indian legal system looks at it, and then eventually we'll take a quick look at some of the international stuff as well. So welcome, Mirav, and thank you for joining us and making time for this.
Thanks, Samanoj. I am Sachin Kalra. Maybe name may be reflecting of Mirav, my son's name.
Oh, that is your son's name. Oh, I was so sorry, really confused. So we have Sachin Kalra. Yeah,
no, he's wonderful.
All right, so I will just quickly change your name that is reflecting here on the video so that. Right, so we are sorted. Great. Wonderful. Yeah, even I was a little confused for a moment that, because I remember a different name from the poster, and then, yeah.
Maybe
great.
Zoom works for the students more better than us because we are into different platforms. Wonderful. Wonderful connecting to the LawSikho and the team of yours. If we talk about today's topic, this is a recent topic which I thought of is better to share knowledge on the subject, which is live and which is encouraging to the team and the students and the people herein. If you remember the 29th of June 2020, there was a press release which came forward stating that government bans 59 mobile apps, citing few reasons of sovereignty, integrity, defense, and security, and also state about that it is blocked as per the IT Act along with the rules on 2009, saying that it's an emergent nature of threat is there, and accordingly these 59 apps been blocked. See, as per, if I go to the provisions of Indian IT Act, section 69A, it clearly states about where the central government or its officer, means it says where the central government or its officer, especially authorized by it, satisfies himself in the interest of sovereignty and integrity of the India or defense of India or security of the state or public order for preventing any offense with a reason to be recorded. There is a restrictions on that which says there should be a reasons to be recorded in writing by order, direct any agency of the government or intermediary to block those sites, those transmissions which have been received, hosted by the computer sources. So basic requirement of 69A, if you see that in an Indian Information Technology Act, it says about sovereignty, integrity, defense, security concerns. With that second major thing is that central government or a person authorized by it should be satisfied basically that there is a requirement to block those sites, and he has to record those reasons accordingly. This is what 69A says. The best part of release is that it says 69A, it says about the rules, but doesn't say which rule. There is a specific rule 9 which states about the emergency route. There is a route which is said to be emergency route, wherein the entire step of putting up reasoning, putting up the process is curtailed, and the person authorized can so moto with the approval of secretary DID may block all sites within 2 days of his satisfaction. And this basically a process. If I say there is a process which is to be followed, there needs to be a committee, a government committee to be formed by it under DIT, and the opportunity to be heard. This is also a big concern which comes up with opportunity to be heard to be given to the originator. This is also need of a 69A. Even if you remember, long before, there was a famous precedent case which was Shreya Singh's case was decided. This also get that 69A said that validity is there. They said it's constitutionally valid, but the originator should be given a chance to be heard, and with hearing, he also need to be reasoning should be given and record by the person who is doing the act. That's what is the concern basically is.
Right, right.
Moreover,
And the Sachin, government has also formed an inter-ministerial panel, I think, for this purpose of this hearing, where they are giving an opportunity to all the apps to come and.
I'll give you how process works. The
Sure.
process of this is that in the under DIT there is a process of designated officer, a DO. Then there is a nodal officer. Then there is an intermediary contract also, who as an intermediary contract who can approach the nodal officer, and nodal officer further approaches DO. The DO will take this matter by satisfying himself. Each stage there is a satisfaction which comes to, and then DO will take this matter with the chairman of examination report. When they are satisfied, accordingly, Chief Secretary of DIT will pass an order of blocking with the recommendation of DO, and then all websites are blocked. This happened past also, and the other way around of legally, if I say there is an order from the court wherein websites have been blocked. This is a past record also, and it continues till now also. Hearing, seeing the scenario, seeing the agenda, it shares about the exigency is there. It says the emergent nature is there, but Section 9 rule is still absent on the press note.
Right.
Is to be mandatory obtained by that. If I give you the blocking procedure, is that there is a request which is to be given for the blocking to a nodal officer, then to a DO under Rule 6. DO approves and send to Chief Secretary, and then thereafter Chief Secretary will approve that accordingly. The basis of the report, this will be blocked. This is what the process says about in the Indian IT Act. However, Section 9 says about blocking of site in basically without any delay is acceptable under Section Rule 9 of the IT Act.
But if it is under Rule 9, then it is only of a temporary nature, right? It's an interim order.
However, my personal view is that this is an interim order which has been passed. Definitely, what I got to know that by regulatory partners in different these all website companies, they have approached the government. Government have given the chance to hear them. They are filing a representation. That's the procedures they are following. There is also a review committee which comes in picture. Any sites which have been blocked within 2 months, it should go to review committee, and review committee also needs to satisfy whether it's to be blocked or not. Other procedure which I feel with these app storage is that they can move to Supreme Court under Article 19 and put up clearly how this site's been banned without any.
Right. By filing a writ petition.
Filing a writ petition. That's a right of any person who has rights been infringed. That's the other way around on that. Apart from that, which the topic says about what is going to international treaty about, how WTO is to look into this. So definitely we have a bilateral treaty with China.
Yes.
Apart from that, we are member of WTA.
Right.
WTO has two functions. One is that GATS. One is the GATT. GATT is the General Agreement on Trade and Tariff, and the GATS is the General Agreement on Trade and Services. They both will be applicable to these apps differently. Like for TikTok, for UZ browser, GATS is applicable. There is a service part. For the scene side, there are deal of clause, fashion side, the dealing sides basically. The GATS is applicable. Both sides, both treaties and treatment, these agreements are applicable to the parties. There are exceptions. There are exceptions under Article 21 of GATT and Article 14 of GATS, wherein in emergency circumstances, the treaty, the agreement can be prevented by both the parties. That's the scenario which is to be built. In case tomorrow China government wants to file a case, a dispute before this W2A, they have to follow a process, which is a defined process basically, which we say. And that process is a conciliation process. Starting from the conciliation process, there is a consultation which is to be done. After consultation, there can be if both the parties don't agree, then there is a panel establishment. Examination will be there. There will be a report which will be prepared. In case the losing party loses, there is a report which is prepared and it need to be implemented by that party. If it is not been implemented, then the VAT can also levy a compensation and also debar the country from WTA. This is how it works in the scenario. So far as Indian judicial systems are concerned, Supreme Court has already given its clarity on 69A, which has been followed by in multiple judgments.
Right.
And has been followed earlier also. There has been Sneha Kalia case of games app to be blocked. That was not an app basically, that was a game to be blocked where kids were being killed because of that game. That also been upheld, however, that was not an app process. Similarly, 69A has been validly said it was valid. Apart from that, if I give you a few examples of WTA also, there are rulings and exceptions for WTA also. In 2014, Russia and Ukraine, they went into a dispute wherein Russia blocked the trade between Ukraine and Kazakhstan routing through Russia. Because of when the concerns came, it said that Russia stated that Ukraine, after having political turmoil there in 2014, because of political and economic differences, there is a restrictions been done. WTA body stated very clearly, for political and economic difference, that cannot be considered as an emergency in international relations. And accordingly, right, report was submitted to Russia and they were not supposed to follow that report.
Right. So,
yeah.
Right. So we will look into in detail into BIT issue as well as the issue of BIT and WTO. But for now, I just want to ask you that if obviously this is the repercussions is very clear, the context is clear that there is a this was a trade retaliation of some sorts. Although that is not how, nothing of the government documents reflect any of that. Rather, the effort has been made to make it look like a data privacy issue, that we are banning these Chinese apps because of a data privacy concern. Now,
if I tell you, it very clearly states that in the interest of 130 crores of population, these apps have been banned. This is what the statement as in the press release comes up.
Right.
Yeah.
So, given this stand of the government, how tenable will it be? Because it is something that the background is very clear, because there would be issues related to whether there are so many other apps related to data privacy, and it's a common issue in India. In fact, Indian government's own systems, Aadhaar, etc., has faced a lot of criticism regarding data privacy, data leak, and this is not something exactly new.
Ramana, so far as the legality is concerned, government is very well in its rights to do that.
Right.
Subject to they can justify their act. Subject to they can prove that really, with the number of complaints we have gone through the data, we have seen that there is a security lapses in the interest of sovereignty and integrity. All those things with reports which they have to have already been prepared behind releasing the press release. Whether it has been done on that is to be seen by the eyes of the court of law.
Right. Of course.
And even I feel the app owners also may have already approached the government with their representations, and government may also call them to give their presentations. Accordingly, seeing that
government has called them, yes, of course. Yeah.
Accordingly, seeing that may open the app also. If you remember, in 2019 only, TikTok was banned by Madras High Court order. Later on, TikTok appealed in the Supreme Court, and then the website started functioning again. So there are way forward ways to available. But in case if I tell you on the international scenario, China itself
has banned many apps. Yeah,
already has a comprehensive internet regulations known as the Great Firewall of China.
Right.
Wherein Facebook, WhatsApp, YouTube, Twitter, all are banned, stating that this is in the interest of internet governance of the citizen and sovereignty of the country.
Correct.
So that's a defense for us. We can also do that. And I say, if government has done something with a backup, without backup, it's difficult for the government. With the backup, it's always going to be helpful.
Right. So this is one area of concern, because China has been doing this against all foreign apps, more or less, like, no matter from which country, from Korea, China, from Japan, right?
Not only China. Australia has banned WeChat for their armed forces. US has banned the fitness app trackers for their forces. So there are instances which are there.
No, banning it for the forces is one thing, but for banning it from operation in the entire territory, it's a blanket ban is quite.
China is blanketly banned those sites.
Yeah, absolutely. They have banned many apps.
Only issue which we may face is that discrimination, which may come up before
discrimination. Right.
It should not be avoided. We should have concrete proofs to have those.
Yeah, and India has not taken any action. We use a lot of foreign apps, and to be honest, many apps, even apps from other countries, we are using some of the Russian apps sometimes. We don't know, like, people download apps from the app store. It could be a Russian app, it could be an American app, could be a Israeli app.
You see, the lockdown, this lockdown has given one basic thing to everyone.
Right.
That's a digital approach.
Right.
So today you are in Zoom. I think so. Before lockdown, no one was using Zoom.
We have been using it for webinars for the last 4 years, but in classes also.
So this lockdown is giving multiple app downloads.
Yes.
Towards Zoom, Cisco, and all those things.
And there has been a lot of arguments about Zoom also. Like, people repeatedly said Zoom is a Chinese app as well, and all of that. So
that's people news which comes up and goes away. It's all should pass through a lot to law and security processes. Right.
So from that perspective, India has not taken a comprehensive step against other apps. I mean, that is also another area of concern. So I would expect that, the government, if they have taken steps against Chinese app, it would have looked much more cleaner and better if they took steps against other apps as well, which are causing data.
So far I can see that government of India cannot ban things until they have concrete proof. They have all backup in their hand. Then only they have gone forward. They have multiple reports. They have everything available.
Right.
They have not mentioned Rule 9, but they have said, as per the rules covers all.
Right. So let's take a look at. Let's try to understand the issue a little better. What is exactly the allegation against these apps?
The allegation against these apps basically is that they are using the data. The privacy is the big issue. Data and risk of the citizens of India. Security is a major concern. There are multiple reports, multiple basically complaints before Ministry of Home Affairs, before cybercrime cells, coordination centers. These all are together.
Right. And what are these allegations before MHA and cyber cell?
So the allegation is that they are entering into the India's sovereignty and privacy of all citizens.
Okay. And how are they doing that?
And everything data is being basically stored in the servers outside India, and all things are being captured. That is what they are putting up. And then accordingly, the government of India has banned these apps in mobile.
So I'm just trying to understand, Sachin, if I look at it that way, even Gmail, when you use Gmail or use Google, all our data is getting stored outside of India through that as well, right? So it is data localization is not even a legal requirement in India, and we don't have data. We don't have those data centers in India, huge data centers.
Data localization basically on financial sector. That is a regulation from RBI and insurance sector.
Correct.
Others there is no such regulation. But however, in the benefit of interest of the Indian citizens, it's must. GDPR has that regulations. Our data privacy policy, which is draft rules, that also has that regulation, but still not
implemented. We don't have a comprehensive data privacy rule. We have a 2008 data protection rules under the Information Technology Act, but it does not. It's not very detailed.
It's limited. Which is limited. Which is nothing says about the server outside India. But there are instances which I can say we've been using Gmail, Yahoo. If you remember, long now it has come LinkedIn and Facebook. Earlier it was Orkut and all those things. Everywhere you've shared the data. Our laws are becoming stringent day by day, but still way to go.
Yeah. So if I look at the language of the MEITY, the language, they are saying that these mobile apps are stealing and surreptitiously transmitting users' data in an unauthorized manner to servers which have locations outside India. Now, this could be... Yeah, please.
Ramraj, stealing means basically what the data they are saying is encrypted, is not being taken by someone. Those data, if it's been taken, if I say today I'm live on a live video with you, and a background of mine gives you a picture of my entire data, if that's been stolen and given to third party without my consent, that's basically a concern. It may be a concern for everyone.
Right. So that apart from of course, if you're using this app, there is an understanding that it will take your video and transmit it. But what if it is going inside your computer and getting other data and passing it off to somebody else? That is the allegation.
So that's what I'm saying. Each computer has everything today. All passwords, all financial pictures, every data.
Right.
And data can be a simple also, data can be a large data also, which can impact organizational data.
Right. So these data is not authorized to be shared, but some data we are authorized to share. That okay, whatever is in the screen, you share.
Whatever you are sharing with the consent is okay. Without consent, whatever is going, it's only problem is this. Just understand a point.
So the allegation is that they're sharing more data than that. Now, basically, this is a very factual thing, right? This has to be, there will be either any proof or not.
This is a factual thing. One second thing is they have to very clearly showcase what all data has been leaked, what instances they have seen into, which I also don't know because there's a government document, which is with the government.
And government hasn't said anything. No issues, nothing they've said on this.
Nothing on that. Maybe with the representation filed by the other side, they will clear the things what they have. Tomorrow, if someone goes to court, then they'll clear the things what they have available. But that's the scenario. But now, if you the question comes to the public also. If you see when you log into any app, first thing is that you give your consent. You give them that you allow us to get into your gallery. You allow us to see your data. You themselves are giving a consent to the person. But consent cannot be over and above the sovereignty and integrity of the country.
Correct, of course. And also that the purpose of that consent is understandable, that you are going to use it for very limited purpose. You're not going to take it and give it to cyber criminals for that matter, right? So that is not covered by the consent. So I think this is very interesting because this is a very factual question which there will be either any proof or not any proof. But if there is proof, then of course there is no question. All the 59 apps would not be able to do anything about it. But
test of law needs to be cleared.
This is a factual question. It's a question of fact more than law. That whether there was, because a very specific allegation has been made. So basis of this entire ban is a very specific allegation which needs to be proven now. So this is very interesting. So the understanding is that by the interministerial committee will take a decision which is appointed by the government, take a decision by around 10th July, I believe, because they have to take a decision within 7 days of hearings.
The process says about that, the process to be followed within 7 days. Entire process to be set up within 7 days. They have to come up clearly on that. The committee to be formed. With committee, the DO will present this to the committee. Entire process. Accordingly, committee will give the report, and then report will be finalized.
Correct. So basically, it's 10 to 15th July should be by when we'll get to know, because all of the apps. I don't know if all the apps will even come to make a representation, but some of them will, right? So
So
it remains to be
whosoever is earning revenue from India, they will definitely go and get it done.
seen. Yeah,
Basic thing is the revenue behind that.
right,
Yeah.
of course.
And apart from that, no one wants to have it banned. It gives a bad impact, reputational impact. And for reputation also, they will go and represent themselves before the government.
Correct.
That's the plan.
So that will be step one. Obviously, I don't think people would be approaching Supreme Court before that, simply because if you're going to the Supreme Court before that will be premature. Supreme Court, even they would want to know if you have made any representation to the government.
I don't think legally it is premature because they have been impacted.
Right.
And impact that they are right. Right can be, they can approach the Supreme Court also directly. Only thing is that then government has to come up with the clean hands with the document before Supreme Court stating that why they have blocked it.
Right. So government is most likely to take a defense that this is a national security and defense matter and we cannot.
So national security matter also, they have to follow the rule. They have to follow the process. Unless until they are able to say there is an emergency which has come. There is emergent in Rule 9 that they can place. Then they can do that. If they cannot place Rule 9, then they have to follow this process which they have not followed. Then also Supreme Court come in picture. They can appeal that this press release can be dissolved.
Right. So also maybe, it can be the situation that different apps will be treated differently because obviously each of them, this is a question of fact and in each case
every app has to represent their case their own. And every app needs to be looked separately. You cannot club all apps together unless until the background is same. And you see one major concern of mine is that in last couple of years, except from the court orders or some URL has been blocked by the government. This is against one country apps only.
Right. So some media reports have come which have suggested that during the hearing, the app companies will be asked to clarify if they have in the past or in the future. I mean, what is the rule regarding sharing their app data with Chinese intelligence agencies as well as government authorities? If they ask for the data from the Chinese app companies, do they have to give it or have they shared it in the past? So what if they come and I think TikTok has already stated publicly that they have never shared data with the Chinese government. So do you think
if an IT person, if I say the legal and IT person, I can say you this every app needs to be looked separately, and while looking separately, you have to see the processes behind that. You have to see the security measures which they have, what encryption formulas they have, what privacy label they have. After that, also, if there's something which has come to in hands of government, then definitely that site should remain banned. Whichever sites comes with a clear picture, it should be open for the requirement.
Right. So let's take a look at the understanding of what happens in case of a bilateral investment treaty claim if it is made by China. So not by China, it will probably by the investors will individually come and file BIT. They start proceedings against India, and India has a bad history of losing a lot of investment treaty matters in the past. Just to explain to the viewers what the bilateral investment treaty is, that Indian government has entered into a lot of bilateral investment protection treaty with a lot of countries. So for example, I think we have a bilateral investment treaty with most countries in the world. And what does it say? It says that the most of the world have entered into bilateral investment protection treaties. And when you sign a bilateral investment protection treaty with another country, the chances of getting foreign direct investment from that country goes up manifold. The simple reason is that what the BIT says is that there are different clauses, and every BIT can have a different clause. But basically, what it says is that your investment here will be given the same protection as any Indian business, and actually more than that. What happens is that if government takes any action which actually becomes an expropriation, an act of expropriation. Expropriation is that government taking over the property of a company or a business. Now, if that happens, or you do anything that vitiates the investment, or the fruits of the investment cannot be enjoyed by the investor, then they can, depending on the provisions of that treaty, they can start an investment arbitration against the government, and then the government may be liable to compensate the investor. Now, this is, I think, something that we might see. Of course, first, I expect, anybody who has a problem with this decision will go to Indian court system. But given that Indian court system can take a long time, will probably delay things. And if they don't get a satisfactory answer in a reasonable time period, then there's a high chance that they might start approaching bilateral investment treaty remedies. So, what are your thoughts on this, Sachin?
So definitely every country who is investing in any country, they have a bilateral treaty, and India has a treaty with all countries, including China also. The treaty is very clear. So in case of any dispute, the person, the company's organization can file a claim application for resolution. There can be international arbitration between the parties. China can also take a lead on that, because the investment which is coming to India is basis the bilateral treaty only, and there is a free trade motion in that how the trade will function. You will not, as you rightly said, you will not be disparate with the local brands. You will be on equal or higher to the equal also as per the treaty. Those all things will come in picture. Only thing is that till the time they go to that step, before that they have to pass the test of law here only before the government of India. That yes, they have not breached any law, they have not breached any security, they have not breached any data. With that report clearly, then they can move ahead. However, China can definitely move to GATS and get, as I told you, with the W2A. Seeing the scenario that why the apps of China were only blocked, and what was the concern behind that. But for that also they have to present that entire report.
So, couple of very interesting things. One is that India and China bilateral investment treaty stands terminated as of 2018. So, on 3rd October 2018, India terminated around 60 countries its bilateral investment treaty, because we came up with a new BIT model saying that we don't want, because we have been losing a lot of cases in BIT investment. Yes. So, especially there was one matter of, I think, Entrix, satellite system. So there was a huge award against India of some, I think, $500 million or something.
So there are multiple cases. If you remember, the Vodafone case still going on.
Of course, yeah.
There's a big case that the retrospective effect of
taxation,
retrospective effect of taxation. And then investment of Vodafone, entire investment is in question. That case still going on. So there are multiple cases, and these cases will go forward. In case of scenario didn't build up for this application also, China will also file a case, or the company will also file a case under bilateral treaty. However, this, as you said, right, 2018 this treaty has not been amended, not been extended.
It terminated it. India denounced unilaterally and terminated it. But what happens is the treaty also says that if not agreed otherwise by the parties, then for 15 years it will affect for the existing investment. So basically, anybody who has started investing in India after 2018.
All these investments, rightly said, I also remember that all those investments is much prior to that, 2 years period is prior, and they have a right under bilateral to go forward.
Right. So there's a high chance that they will be approaching the
There's a high chance. But before that, they'll definitely find this approach only with moving to government, filing representation, and getting much better results.
Yeah, and interestingly, it says that the host state cannot act arbitrarily. The BIT, India China BIT, says that India cannot act arbitrarily. So it again comes down to being able to justify the action on the grounds of data theft and what we have claimed. Because that would be that'll be a very important document, right?
The basic crux of entire litigation, whether it is before WTO, before the bilateral treaty, or Indian courts, or before the government also, the crux remains same. The facts which are mentioned, which we concrete with the evidences, those evidences should demonstrate clearly that those acts of these app providers have taken my data, have taken my citizens' data, shared it with the outsiders, which are not allowed. Outsider may be any foreign entity, not only China, it may be others also.
Yeah.
That needs to be very clearly demonstrated, and then accordingly, we personally feel that things can work out.
Right. So in that case, if we are not able to prove that, then there is a danger that all of these companies will be able to claim huge compensations under the respective BIT. As far as WTO is concerned, how could that play out in your opinion?
So WTO, as I told you, WTO has a special process on that. We are a party of WTO. China is also a party to WTO. This entire process of these apps, basically, which are providing services or trade, they are covered under the particular treaties and agreements. In case of dispute, they can raise the concerns before WTO. WTO has a set up body. First of all, they have a process of 60 days consultation, which is said to be conciliation, basically, for my purpose. If both the parties all together concile and resolve the issue, is much better with the facts. In case that it doesn't happen, then there is a process of panel establishment. A panel is set up to settle dispute, like arbitration panel. Similar panel tribunal has been set up, which will look into the complaint, submit his report. Panel will submit a report. In case one party loses that, he has to comply with the report immediately.
There's also a provision for appeal to the WTO appellate tribunal.
Yes, appellate is there at last, basically. There is appellate review is also there, which is always there. But post report, it is to be implemented. If it is not implemented, then other right is one is the appellate right. Other is that it is not reported. Then the losing party, WTO can bar them or put up a compensation also.
Right.
This is all under article of WTO settlement understanding, which is said to be a dispute settlement understanding. In Article 4 to Article 16, it states clearly about those things. Consultation is in Article 4. Then we have panel stage in 4.7. Accordingly, it works. Report is in 17.4. Non-implementation is on Article 3.7. And compensation, which can be granted against the party, is 22.2. This is how it works.
Right. So all of these, WTO as well as BIT, all the international treaties always have a essential security exception. So you can create a security exception that this is if you do it in a non-discriminatory matter, interestingly, that if you can show that, this is a danger right now. I think this is actually something in favor of India.
As I told at my beginning also, Article 23 and Article 14 of GATS and GATT clearly says about exception. In case of emergency, there is an exception which is to be triggered.
So what could be the emergency? How do we justify that emergency as a legal case?
So we can only define the legal case of emergency by saying that this data was my data, which is threatening my sovereignty and integrity, which has a data which is really a data which gives a better end of my territory, my surface, my people, and my basically data would be arms and ammunition data. Data can be data of my.
Correct. So in that case, the data theft will not matter. Even if you believe that there is a capability, so you are at war with another country or with a border dispute or any kind of armed conflict with another country, or you believe there's a reason, you could say that it is non-discriminatory if the other country has access to my data in such a way that which can jeopardize my situation, and I withdraw that access. It is still a security action and it is non-discriminatory because with other countries I am not at war, right? So if I was at war with other countries, then I would withdraw their data access also. But in this case, potentially the data can be weaponized and used against my country. It can be harmful to the security of our country. So even if there has been no data theft so far.
So if you see, the notification very clearly said cyber security is a concern basically. In the cyberspace, the last para of this notification space is about cyberspace.
Right.
Basic concern is the cyberspace. There is a data theft which can create a cyberspace theft to me. Theft can be a cyberspace in the sense financial theft can be done. Any action which can lead to anything of. Even cyberspace means all things are a technology. All things are coding. If they have my coding, then they can move to my sites and my data anytime.
Right. So I think this looks like a more tenable defense, because it might be hard to prove specifically that what data has been stolen and all of that. If government has that, well and good. But in case they do not have, this could be a potential defense that it is an essential security requirement that I cannot allow these companies, which are essentially under the control of the Chinese government, and the Chinese government can anytime access this data whenever they please, and it would put my country's and the people's security at risk. So this could be a valid. I mean, it can be.
This is also may.
Mm-hmm.
This is also may. I don't want. I can't. You can't rely on may. Either you might have a policy common for all blocked all the applications outside India.
So that would be that fine. That would be non-discriminatory. But when you have to discriminate, we do not want to, or possibly are interested in blocking each and every app from around the world. But if we are interested in blocking the Chinese app specifically, what could be a valid legal argument? I think this is one of the valid legal arguments under international law, that we are at war with this country, or there have been, there's a risk of war. And
the best scenario at present is that only we are running with the risk of war with this country right now, wherein one of my borders been in a difficult situation right now. Tension is very high. There can be a defense basically, but with that defense, we need to have concrete evidence of whether this app really has done it. Why 59? There are multiple apps which are other than the Chinese apps are there.
Mm-hmm.
There are apps which are in. The question maybe this also. No? This is one of the questions basically which may come into, like LiveMe. Still continues. LiveMe is also a Chinese app which I got to know.
Achha. Okay. Right. So that is also an issue. Do you think, there are two questions I have at this point. One is that, do you think government could handle this issue a little better? Because there have been allegations of lack of transparency and not following the entire process the way it should have been, even laid down under the IT Act itself. So that is one concern. The other concern is that, do you think this will push the government to bring the data security and data protection law faster into action?
So coming to the first question, definitely it could have been much better. Now also they have done their best, seeing the emergency situation. They can give the justification on that. This is only way of doing that in 2 days. You can block the site, seeing the emergency situation. My data has been cyberspace, and data has been stolen by the third party or sent to a third party for a usage. They have done their best, but it could have been done better by giving a opportunity to the other side, proper setting of 7 days by DON, the body. Each app service provider should have been asked to present their case. Accordingly, they could have done, because already this report which says about there are multiple complaints. Mm-hmm. With these complaints, it also says Ministry of Home Affairs, CERT, and other ministries have taken the complaints long back. So already this might have worked not today. This might have worked a couple of days before. When it would have been done, it could have been done with the process which has been followed under 69A.
But it has also been argued by many lawyers that 69A is a content regulation tool, and you cannot use it to ban entire platforms. And if you're banning platforms, then basically it cannot be for data security. You have to say that this is the content which is violating the Indian law, etc., and or harmful content, and therefore you can ban it. But to actually, and you have to provide samples of the offending content. In this case, that hasn't been done.
But in this case, they have taken the defense of threat of emergency, no? The threat of emergency, they are putting on the rule 9 only. However, they have not mentioned that. This is what the way this press release has come up.
Yeah. So that is also a technical problem.
It's a technical problem basically. But definitely, the blocking can be done.
No, but to apply a rule, you have to go by a substantial section. And the substantial section they have chosen is 69.
There is a proper provision in that, and provision should be followed in a spirit of law, so that tomorrow it should be very clear on the fact.
Correct. But that raises a question, and this is being debated on the internet, and by many lawyers have written about it. There is a question regarding
Second question. There was second question of yours. Then can you just
about data protection? Sure.
So, if I remember, I was in Mumbai last 2 years back, 1.5 years back. I was with Mr. Justice Krishnan on this, who was behind this entire data. He also is of the view why it's not been implemented. I also personally say that data privacy rules which has been framed are the need of the hour, not only for the Indian securities, but for the companies also, which is the spirit, which is the basic requirement for the citizen of India also, because you never know where the data is going and how it is going on. Government itself says earlier, you give Aadhaar. Then in Aadhaar, he said you will get virtual numbers. Then you give virtual numbers. Till the time Aadhaar is given, the virtual numbers have been floated. Now it is banned that no one will take the Aadhaar number, Aadhaar data, unique ID card. But it's already in the market. Everyone has given their data to. Everyone asked earlier that unique ID dijiye aap apna, you give us all those things. Everyone has given. That's the concern basically which is there. So data privacy law is a must, and it should be followed in spirit. Any more delay will curtail the problems more. Will not curtail the problems more.
Right. Absolutely. There is a question, interesting question from one of our listeners. Astha Arora is asking, my question is that I think Indians working for these apps and companies are in a difficult position and might lose jobs. In the situation, people are already losing the employment because of course, the economic situation. Will the government look into people losing employment, or is there any duty from the state? I mean, we're not talking about content creators, but about people specifically employed.
So my say is this only, see, everything which comes to as an investment gives an opportunity to Indian public. Tomorrow, I don't want to get into that, but if some country has invested, some company has invested in India, or they have come with the process, they have built in the process herein. All employees, 90% of employees are the Indian employees which have been hired. This is an opportunity for the Indians also to gather those things. Samsung India setting up an entire process in India gives opportunity to Indian only. Similarly, other companies who have come to India. So definitely with this ban of app, tomorrow blocking of app, there will be the people who will be losing the jobs. Because when there is no work in the country, they will have to lose the job. How they can survive without revenue? It's all built in the revenue of the company. Accordingly, the manpower is built in.
Okay. Of course, I mean, I think even if somebody is terminated, still that company has to follow the laws and rules. So it's not like an immediate sudden termination, right? They'll have to follow all the retrenchment, etc. Whatever rules and regulations are there for labor protection, employee protection. So I think that is there. I don't know if the government will look into it. That is for the government. Like really, there is no law that says the government has to take care of employees in such situation. But if obviously government could or may not, take interest in that. But in the end of the day, definitely a company which is terminating your employment is supposed to follow certain regulations.
So this scenario, government banning app, tomorrow company becomes wind up. Then also the people lose jobs.
Yeah.
It's not like that. Job is a part and parcel. If someone is doing some illegal activity, that's next to be banned only, if found to be.
Right. There's a question.
And the impact goes long. Impact goes to up to bottom only.
Right. There's a very good question. It says that question is from Athar. He's asking that what would be the what could be possible arguments these companies will take before the Supreme Court of India if they are challenging under a 19, of course under 19(1)(a) or any other freedom 1G for freedom of business and profession. So what would be the action? Like what could be their argument? One is arbitrariness. Of course, they'll argue arbitrariness.
The argument will always be on two routes, which I feel. One is that we have not been heard, we have not been given opportunity.
Arbitrariness.
That is the basic thing which Shreya Singh's case has given to us very clearly. Opportunity we given, and the reason is not been recorded.
Right.
Individually for each web app.
Right.
So these two basic reasons which gives them a right to move to under Articles 226 or 32 in the Constitution of India. Clearly
and also discrimination, right? They can say we have the same data practices as anybody else.
Those are not the sides which will come together, but these are the two tests. And plus, if they can give a demonstration with the documentation, or today, since video conferencing, video live cases are going on, they can demonstrate their entire process to the Supreme Court or the High Court, which they are approaching to.
Most probably they'll approach Supreme Court because it's a pan-India issue.
Pan-India, the Union of India is there involved. They'll go to the.
Right. And also it's a question of the entire country, not of a specific state. So all right. So there's another question saying that of course there is a lot of data already on these apps. So what if the Chinese misuses this after some time? What is the remedy? Like, can we reclaim our data?
Well, first of all, you need to see that what reports comes up tomorrow when they present before the government, whether this data is being leaked or not, or has been shared with third party or not to the Chinese app. So if data has been already given and it's been already been leaked, then the government has to take other further steps, taking the data back or making encrypted. That is a form of doing that.
Right. So, if we take the lens away from the Chinese apps for a moment and we start thinking that, okay, for Indian companies also, if the government has, of course, this is now a precedent that data privacy can be a ground for an app being blocked in India. So for apps from other countries as well, I'm sure they are taking a relook. Even Indian apps may be taking a relook at their data privacy policies. So what would be like the very important, I would say, pillars of data privacy for any app or any media company for that matter?
So data privacy, basically, for each and every app, pillars would be that the purpose basically to be defined, and beyond the purpose, if it has been taken, it has been obtained and used, then it will be a difficult situation. That's what I told you, that data privacy draft rule covers everything together, wherein my data and your data and our public's data is secure enough. And that's a need of an hour to come up and build it, like the European country has built it. It has instances also. A person can raise a grievance also. With that person can also raise a request to delete the data also. Like a minute back, there was a question on whether we have already shared the data with TikTok. The person can write back to TikTok to just give my data back or delete the data immediately. These all rights are being given under the act. These all to be covered under the same. This is only a click away, which Parliament should clear now, in the interest of the country.
Right. So if it was there, then we would feel much more secure about that, right?
Yeah.
And there would be a much better reporting also.
At present also, the person who seems that is an infringer, he can write back to this company's to the nodal officer or to the grievance officer, ask how the data was been taken off in writing, and can have as they have right, we also have a right to privacy.
Very interesting questions on YouTube right now. Mitali Kshatriya is asking, can third parties like Confederation of All India Traders make representations in these hearings regarding these apps? And then, and then there's a question that isn't Article 19 available only to Indian citizens? How can Chinese apps file REIT under this? You want to answer that?
They also have a unit in India which they are working into. They have also a registered company in India also, the parent and a holding company. They are also an entity in India, and as an entity, the rights are available to the entity also.
Yeah, so it's true. Some of the fundamental rights are only available to citizens, and I think freedom of expression or freedom of business is only available to. That's a good point, Mitali, honestly speaking. But I mean that I am not sure. But Sachin, maybe given how can we say that a company registered in India is an Indian citizen and can?
It's an Indian entity basically. It's
so they can
Indian Companies Act.
So if you're registered under Indian Companies Act, then you can.
They have also all rights available with them as an entity.
Okay, that's great. That's great. Interesting. There is a question on this. Can third parties make representations before the interministerial committee, which has been set up for hearing this matter?
What third parties basically?
They're saying Confederation of Indian Industries or trader bodies, and can they also make representations?
They can make a representation. Depends how the government treats it. The representation can be filed to a nodal officer or a DO by them also.
But specifically for the committee, there is no such right.
No
as
such
such.
right.
Not in the law, but I don't know if they can allow. But I think they are in a hurry, given the 7 days, 7 days limitation. If they give everybody a right to be heard in this matter, there will be 500 different.
So that right will be already the right notice will be served by the DO to the concerned intermediary or to the organizer.
Correct. So that's a different thing, but not under this process.
No, under not in the process.
Yeah. So there's a question on. Is there any provision under WTO? Mithal is asking in which under WTO which allows other countries to retaliate restrictions in services? Yes, retaliation provisions are there in WTO law. You wanna throw some light on that? Or?
There are provisions of retaliations basically, but other countries for these apps, I don't think so.
Yeah, I mean, valid retaliation is defined in the treaties, and of course, later on, if you challenge the original act itself, the retaliation will also come under question as to whether it was a valid retaliation.
Yeah.
If you have failed to do so, then and it's very common. Like whenever there are like anti-dumping duties and stuff like that, and there's a dispute.
Those are there.
People do not wait. People do not wait for the things to be taken up in WTO and get decided. They do an immediate retaliation duty and stuff.
Yes.
So definitely they could do that. How? Okay. So some question we've already answered. What to do when government bans your company using same laws? If government, Ishani is asking, if government decides to ban an Indian company under 69A, could they do so? Of course they could, right? So
all rights are available to Indian company also. They can also file representation. They can also move to Supreme Court, and then they can also file. They can also represent their case before the department.
Right. So that is what we were discussing earlier. Also, Indian apps should be a little careful because if this is the precedent getting created in India, there could be action on Indian apps for failing to protect data.
Yes, right.
All right. So I think that kind of brings us to the end of the session. We are at 6:59. There are some more questions that are pouring in. So somebody saying Kerala HC has decided in sprinkler health data sharing that data should not be stored outside India. Well,
but it's related to which sector basically it says about that. Insurance.
And whether it was an obiter or it was actually it was.
That's very clear, and there is a notification of RBI and insurance IRDA which clearly says about that data cannot be outside India, and server should be in India only, and that's basically a clear law. However, other industries there is nothing so coming up, but with the new the rules which has been framed, hope to have this implemented.
Yeah, and there's a question on whether Indian apps could also be banned by other countries for the same reason, by Radistar. So it could be, of course. Data sharing is a big.
China has already banned Facebook, YouTube, Twitter, WhatsApp. So any country can.
Not for data sharing, for other reasons, but yeah. So there's a very interesting question from Ayush Dikshit. He's asking why action is only taken against Chinese app, given that sometime back WhatsApp accepted in US court that Israel was tracking some politicians in India and gave the data to Indian government through Pegasus app using WhatsApp.
So my say is that WhatsApp might have passed the test of law, a test of fact also with the government of India. This is how it works.
Sure. Yeah, that's a good answer. Right. So one question is the multiple remedies which when they're available, can they be exercised concurrently or one after another? That's again a question of strategy, but also a question.
That depends on the strategy, and then concurrently you can run. No one stops running the concurrent strategy, and no one will stop them to file.
Yeah, but honestly, if I feel it could be entirely wrong. When you go to the Supreme Court right now, they could very well say that you are already making representations before the government.
If I say the other way around to the Supreme Court may say you filed representation and government should look into it. This is what they can pass an order. And
correct.
then
They can say without making any representation and
and
giving an opportunity to the government, why have you come?
Other way around will be that they'll ask government to file 30 days. Within 30 days, their report.
Yes.
That is how it works. The functioning of courts works like this only.
Right. So, which is why the parties may decide to get an order, because they are supposed to get an order in 7 days and then only move to Supreme Court.
Yes.
Makes sense.
Yeah.
All right, because the Supreme Court will give a lot more time to the government otherwise. Right. All right, I think that brings us to the end of the discussion. Questions are now suddenly pouring in on YouTube also.
So you can share the questions on my mail. I can drop my answers to all you guys.
Sure. So why not some parting message from you? Also, if people want to get in touch with you, what is the best way to do so?
I repeat there. I just missed you in between.
If somebody wants to get in touch with you with some questions, what is the best way to get to you? Is it like LinkedIn or Twitter or?
So I'm available on social media. I'm always available. Plus on my Gmail ID, I'm always available.
Okay. Would you like me to share your Gmail ID? Just worried that it is going to too many people.
Yes. So you can share. You can share that.
Okay. Well, I'll share that. Please tell me your Gmail ID. I'll type it out for everyone.
Sachin Kalra DV.
Kalra
DV.
@gmail.com.
And you can share my LinkedIn account also if someone wants to put in questions.
Right. I'll do that. So kalradb@gmail.com.
D for Delhi, V for victory.
So it starts from Kalra. Sachin is not there in this.
No, Sachin Kalra, both. Full name.
Why do you write Sachin Kalra DB? Achha.
Yeah.
Sachin Kalra DB@gmail.com. I have shared with everybody, and I'll also share.
Not DB, Ramesh. DV, V for victory.
Oh, sorry. I'm so sorry.
Yeah.
This is the wrong email ID. I'm sharing again.
Ayush says that I have connected with you in LinkedIn. Great, Ayush. Look forward to discuss with you.
Yeah. So any of you want to find Sachin, you could go to LinkedIn. It's very easy to find. Just type out Sachin Kalra HT Media. You will find it very easily. In Google also you can do it. But I'll still share the link once quickly. Okay, got it. There's a bit of text screen at the end, but that's okay. Should be fine. All right. So thank you everybody, and thank you so much Sachin for making time for this session and sharing your valuable insight. This is a difficult topic to navigate. There are so many people who of course look at it from a lens of patriotism and saying that our country, let's support, everything is great, but at the same time as lawyers we need to look at the legal angle and understand how the process is working, and tomorrow we can support in our country in doing these things even in a better way, right?
We all are patriotism, and we all are Indians. So we love our India first. But however, the laws are all applicable to all things. It needs to be followed in spirit.
Right. And then of course, like making sure that I think the situation has come where maybe we will make a great impact on the international arena also, and this is an issue where international law will come up, and we need to understand how it works. So that's great, and thank you everybody for making time for this and joining us and sharing your time with us. Do share your feedback. Do write about this session if you learned something interesting, do share it on LinkedIn, tag Sachin, tag me, let us know your feedback. Would be wonderful, right? Thank you everybody. Take care.
Thanks, LawSikho team. Wonderful talking to you guys.
Thanks, Sachin.